Imagine waking up one morning and realizing you cannot speak, cannot write your name, and cannot tell anyone what you want done with your own money. Your bank accounts are frozen, your bills are piling up, your family is panicking. And the worst part? This is all happening not because someone stole from you, but because the law stepped in when you lost mental capacity and nobody had the right paperwork in place. This is not a story about old age. This is not a story that only happens to other people. This is a story that can happen to any one of us, at any age, without any warning. And right now, there are 4 specific types of accounts that a judge can freeze the moment you lose mental capacity, locking your loved ones out completely unless you take action today. Stay with me, because what I'm about to share in the next few minutes could save your family from years of heartbreak and financial chaos. Welcome to James Retires, the channel where we break down the financial and legal decisions that actually matter for your future. If you are new here and you care about protecting what you have built, hit that subscribe button right now and tap the bell so you never miss a video like this one. And if you are already part of this community, welcome back. Let us get into it. Before we talk about the 4 accounts, you need to understand something that most people get completely wrong. Losing mental capacity does not have to mean a dramatic event like a severe stroke or a serious accident. It can be as gradual and quiet as early stage dementia. It can happen from a traumatic brain injury. It can come from a sudden medical emergency where you are placed in a medically induced coma. And the moment that happens, unless you have specific legal documents in place, the courts can step in and take control of your financial life. The legal process is called guardianship or conservatorship, depending on the state you live in. And once a judge appoints a conservator to manage your affairs, your accounts can be frozen or heavily restricted while that process plays out. We're talking weeks, sometimes months, and sometimes years of legal battles, all while your bills keep coming, your mortgage needs to be paid, and your family has zero access to the money they need. Now let us talk about those 4 accounts. The first account type that can get frozen is your individual bank account. This sounds obvious, but most people do not think about the implications. If you have a checking or savings account that is only in your name, with no joint owner and no proper power of attorney in place, that account becomes completely inaccessible the moment you are deemed mentally incapacitated. Your spouse cannot touch it, your adult children cannot touch it, your best friend cannot touch it. The bank has a legal obligation to protect your assets, and without a court order or a valid power of attorney, they will not release a single dollar. Even if your family walks in with proof that you are in the hospital, even if they bring your medical records, the bank will say, "We are sorry, but we cannot help you without the proper legal authorization." So your electric bill goes unpaid, your car payment goes unpaid, your mortgage goes unpaid, and the stress this puts on your family during an already devastating time is unimaginable. The second account that can be frozen is your individual investment account. This includes brokerage accounts held solely in your name through platforms like Fidelity, Schwab, Vanguard, or any other investment firm. These accounts can hold tens of thousands, sometimes hundreds of thousands of dollars in stocks, bonds, mutual funds, or ETFs. And yet, if you lose capacity and there is no legal authority for someone else to manage them, those assets sit completely locked away. In the meantime, the market does not care about your situation. Your portfolio could be going up, going down, or sideways, and nobody has the authority to make a single trade or move a single dollar without a court order. The conservatorship process to get that authority can cost thousands of dollars in legal fees and take months to resolve. The third account type is your retirement account, and this one surprises a lot of people. We are talking about your IRA, your 401k, your 403b, or any other individually held retirement account. Many people assume that because they named a beneficiary on these accounts, everything is automatically taken care of. But a beneficiary designation only matters after you die. It does nothing while you are alive and incapacitated. If you are in a memory care facility and you need funds from your IRA to pay for your care, but you cannot consent to the withdrawal and no one has a legal authority to act on your behalf, that money is locked. The facility needs to get paid, but the court process has to play out first. And again, the fees, the time, and the emotional toll on your family can be enormous. The fourth account that can be frozen, and this is the one that shocks people the most, is a business account or LLC account held solely in your name. If you are a small business owner, a freelancer, a real estate investor, or anyone who runs financial operations through a business entity where you are the sole authorized signatory, losing your mental capacity can bring your entire business to a grinding halt. Your employees cannot be paid. Your vendors cannot be paid. Your clients cannot be served. And the business you spent decades building can start falling apart in a matter of weeks, simply because no one has the legal authority to sign a check or approve a wire transfer on your behalf. Now here's the good news, and I want you to stay with me, because this is the part that actually changes things. Every single one of these situations is preventable. The legal tools already exist. You just have to use them. The most powerful document in your financial protection toolkit is called a durable power of attorney. The word durable is critical here. A regular power of attorney becomes invalid if you lose mental capacity, which is exactly backwards from what you need. A durable power of attorney stays in effect even after you lose capacity. It allows someone you trust, your spouse, your adult child, your sibling, your close friend, to step in immediately and manage your financial affairs without any court involvement. No judge, no conservatorship hearing, no months of waiting. Your agent can access your bank accounts, manage your investments, handle your retirement account distributions, and keep your business running from day one. But there are some important details you need to get right. First, you need to make sure the power of attorney is actually durable. Not all templates you find online or in a basic estate planning package are durable. Have an estate planning attorney review or draft this document for you. Second, you need to think carefully about who you name as your agent. This is the person who will have enormous power over your financial life. Choose someone you trust completely, someone who is responsible, and ideally, someone who lives close enough to actually take action quickly if needed. Third, you need to make sure your banks and financial institutions will actually honor the document. This is something most people do not know. Some banks have very specific requirements about the format or age of a power of attorney. Some will reject a document that is more than a few years old. You should actually bring your signed power of attorney to your bank while you are healthy and ask them to review and accept it in advance. Many banks allow you to put this on file, so there is no question when the time comes. Beyond the durable power of attorney, there are additional strategies that can provide even stronger protection. Adding a trusted joint owner to key accounts is one option. A joint account with right of survivorship means the other person can access the account immediately without any legal process. However, this comes with its own risks, including potential liability if that person has creditors or gets divorced. Another powerful strategy is setting up a revocable living trust. A living trust allows you to transfer ownership of your accounts and assets into the trust while maintaining complete control during your lifetime. You name a successor trustee, and if you ever become incapacitated, that successor trustee takes over management of the trust assets immediately, again, without court involvement. Living trusts are especially valuable for people with significant assets, real estate, or business interests. On the retirement account side, while you cannot simply add a joint owner to an IRA the way you can with a bank account, you can work with your financial advisor to set up very clear beneficiary designations and coordinate those with your overall estate plan. Some people also use strategies like naming a trusted individual as an authorized agent specifically for retirement account transactions, which some custodians will allow with the right paperwork in place. And for business owners, the solution often involves updating your LLC operating agreement or corporate bylaws to allow for a designated successor manager who can step in if you become incapacitated. Some business owners also create a separate business power of attorney that specifically authorizes someone to act on behalf of the business entity. I want to be honest with you about something. These solutions are not difficult to put in place, but they do require you to take action before something happens. The worst time to try to figure this out is in the middle of a crisis. If you are watching this right now and you do not have a durable power of attorney, or you're not sure if yours is actually durable, or you have not thought about your business accounts or your retirement accounts in this context, please make this a priority this week. Not this month, this week. Call an estate planning attorney. Many offer free consultations. Ask specifically about a durable financial power of attorney, healthcare power of attorney, and whether a revocable living trust makes sense for your situation. Here at James Retires, we truly believe that the best financial planning is the kind that protects not just your wealth, but your family's peace of mind during the hardest moments of life. The accounts we talked about today, individual bank accounts, investment accounts, retirement accounts, and business accounts, represent the financial foundation that most families depend on. Do not let a legal technicality lock your family out of that foundation when they need it most. Before you go, I want to ask you something. Do you already have a durable power of attorney in place? Have you ever actually brought it to your bank and had them put it on file? Drop your answer in the comments below. Your answer might help someone else in this community realize that they have a gap in their own planning. And if this video helped you see something you had not thought about before, please share it with someone you care about. Share it with your parents. Share it with your siblings. Share it with a friend who has a small business. One share could genuinely protect a family from years of legal and financial nightmare. Thank you so much for watching James Retires today. Take care of yourself, take care of your family, and we will see you in the next one.